take you out to various parts of the city for you to observe. Then we'll begin taking testimony from witnesses tomorrow. That's the schedule. Is there any opening statements on behalf of the state of Ohio?
Yes, Your Honor. 6 shots in the back, all fired by the defendant into the back of Casey Goodson, with no reasonable basis for the defendant to perceive a threat by Casey. It's an unjustified shooting. Casey was only 23 years old at the time the defendant killed him, and he was a Franklin County deputy at the time. Casey's death is a tremendous loss to his family. He grew up in Columbus. He went to Beechcroft High School. He was very close with his mother, Tamla, and the rest of his family. His family is very proud of Casey. After high school, Casey worked at the Gap and at the warehouse. And he saw all these trucks coming in and out. He says, you know, Mom, Grandma, I want to be a semi-truck driver. Casey did that. He went to school, learned to drive a big semi-truck, and he got his commercial driver's license. He wanted to be on the road. And he did do that. He drove for a company that actually hauled goods for Walmart, traveled to California, every place. After doing that for a while, he decided that, you know, I want to come home. I don't like doing all this traveling. So he came back home and he moved in to his grandmother's house and was working at the Gap warehouse up until the time of his death. Now, the evidence will show December 4th, 2020, as I said, Casey was living with his grandmother, Sharon Payne, at 3996 Estates Place, and that's in Franklin County, Ohio. That morning, he had a dentist appointment, and it was at 9:30 in the morning. Sharon allowed him to take her car, which he drove her car regularly, to the appointment. Sharon owned a Nissan Versa, a black Nissan Versa. Casey sees the certified dental hygienist, Karen Hay. You will hear from Karen Hay. Karen Hay will tell you what type of mood Casey was in that day. She said he was a great patient. That's what she will testify to. He was in a great mood. And in fact, during the hour and a half she was working on his teeth, they spoke about a lot of things. Television shows. And in fact, one of them they talked about was ice truckers, these big semi-trucks that drive across these lakes and stuff, hauling goods. Because Casey was interested in that type of stuff. And actually, Karen watched that show too. He indicated at some point that maybe he wants to go back into driving the semi-truck. He also talked about his job at the Gap. He had goals. He said he wants to move up and gain more responsibilities. He wanted to help out his family. He had dreams. Ms. Hay, after she's done working on his teeth, told him, Casey, go home, take a nap before you go to work. Even suggested, hey, why don't you go get a milkshake or something before heading home because of all the work that she did on his teeth. I believe he said that he mentioned something about getting subs. He's going to take subs home to the house. As Casey's leaving, he hugs her goodbye and is very appreciative and was actually looking forward to coming back at a later time to have his front teeth worked on. After leaving the dentist office, Casey does make a remote order from his phone for 3 12-inch subs from Subway. He picks the subs up in a single large plastic bag. They're all put in one bag. And he leaves just after 12 o'clock noon when he starts to head home. Now, you will see the video from Subway. And you will see the bag as he carries it out. It's a big bag. It's not something really small, but there are 3 12-inch subs in it. You'll see what it looks like when he's carrying it out of the Subway into the parking lot, getting into his car. Now, during the trial, you will see evidence from a surveillance video from St. Matthias Church. And that video shows Casey traveling southbound on Carl Road, approaching the intersection of Ferris and Carl Road. Just going to, so that we can orient you where this is. It's the snowflake. Courtney may have the, oh, I touched it, I'm sorry. Okay. So the video shows Casey traveling southbound on Carl Road here. I don't know why my pen's not showing up here on the screen. Pardon me, I hit something. Oh, the snowflake. We ready? Okay. So the video will show Casey traveling southbound. This is Carl. And here's the intersection of Carl and Ferris. So he's approaching this intersection right here. You also see in the video at that time, the defendant is in an unmarked U.S. Marshal's truck. He's traveling westbound on Ferris, approaching the intersection. The defendant stops at that intersection. He has a red light. Casey, as he gets to the intersection, the video will show that Casey makes a continuous left-hand turn onto Ferris. A continuous left-hand turn onto Ferris. He then travels on Ferris down to Estates. As you recall, he lives on Estates here. And he makes a right-hand turn to head home, putting on his blinker, his right turn signal, to make that turn. He then travels down and parks in the front of his house. Now, they lived on the corner of Case and Estates. And it's customary for the family to, when they park in front of their house, Sharon's lived there 20 years, homeowner, it's customary that they park in front of the house, and they park on the wrong side of the street because they're cognizant of the neighbor next door. He's got a driveway or a fire hydrant or whatever. So a lot of times they'll just pull in front of the house and go in and out of the house, instead of going down to the corner and turning around and coming back and now parking in front of the house. This is everyday activity for the family. Casey, upon parking, gets out of the car with the bag of subs and keys. Now, Sharon's car had some issues like maybe a lot of our cars do. The darn thing doesn't lock. There's not a key fob. It locks, but the only way you can lock the car is if you get out and you put the key into the driver's side portion of the car and turn it, and it will lock the vehicle. We know Sharon's vehicle was locked. We know that Casey locked the car. And we know Casey had the Subway sandwiches, carrying them in the house. So with the keys and the subs, after taking time to lock the car, he proceeds to head to the side door of the home. Now, there's nothing unusual about going to the side door of the home because the family uses the side door. Because the front door sticks. The front door is hard to open. It doesn't shut right. So the family uses the side door that's around the corner of the house. And that's where Casey went. The side door to the house is located inside a wooden fenced yard that has a gate. The fence surrounds the side and backyard. To enter the side door, Casey has to step up onto a landing and then would have to take another step to enter the house. There's a storm door. And the storm door had glass. And it has a metal mesh, which you will see. It's got like a metal mesh that's on probably the middle third of the door. And it's for, like, if you have animals, some of you have dogs, okay, where they push up against the thing. It's to prevent the dog or the animal to push the window out or whatever. Casey pulls the store door open first. He has keys, the bag of subs in his hands. Casey's back is turned towards the storm door. So the storm door is behind him. And his back is towards the open gate out towards the front of the house. He uses his keys to open the side door by holding the subs. Now, meanwhile, the defendant had made a U-turn up there at the intersection and pursued Casey. And in the meantime, what you'll learn, he parks his truck at the end of Estates and Case. He comes down here and flies in here and parks at an angle. The defendant approaches the open gate leading to the side door. As Casey unlocks the door to go inside his home, the defendant, using his AR Daniel Defense assault rifle, equipped with an aim point red dot sight. You will see the weapon. This is the weapon the defendant had. He shoots Casey 6 times in the back, killing him. All the shots passed through the storm door, breaking the glass, with 3 shots passing through that metal mesh, 1 striking the top of the frame. Casey's back is towards the direction the bullets were fired from. His back is towards the defendant. After being shot 6 times, Casey is face down in the kitchen. Now, this is a small house. You go into the side door. If you go straight, you head downstairs. You go left, you go into the living room. You go right, not far from the door, you're in the kitchen. This is a very small residence. He's laying face down on the kitchen floor. Face down in the kitchen, his palms down on the floor, his AirPods in his ears, Subway sandwiches on the floor. Casey's keys are hanging from the door. Now, Sharon Payne, Casey's grandmother, and Janae Sanford, Casey's sister, are home with the rest of the family. The whole family's there. There were many children in the home. They all had, not many, I guess 3, to me is many maybe, but there were small children in the home at the time. One child was eating oatmeal at the kitchen table. Looks like when Casey's coming in, about where he fell, you'll see, we don't have photos with him laying there, but you'll see where he was. His head's almost to the kitchen table when the shots were fired. Sharon heard something that sounded like chandelier breaking. Ernest hears something. Janae, gunshots. Casey's grandmother, Sharon, ran into the living room area, was able to see in the kitchen. She sees Casey is face down. She didn't go into the kitchen. She's from the living room. She's able to see face down, not far from the side door, what she looked like bullet holes in Casey's back. She then calls 911, and you'll hear the tape. And she says, somebody's killed Casey. He's been shot in the back. Now, Janae, Casey's sister, also sees Casey laying face down on the floor. She's in her bedroom when she hears it, and she's seeing it from a different perspective. Where she comes out of her bedroom, she takes 2 or 3 steps past the bathroom, and she's able to walk around like this and see. Now, she can't see Casey's whole body, but she also sees that Casey's laying face down on the floor with his hands out. Moments later, Janae again is looking out. As you can imagine, it's pandemonium now. She goes out to try to look again. Casey's been rolled over onto his back, presumably by the officer. Now, there's a handgun that is owned by Casey that was found at the scene. Casey's gun was found on the floor with its safety still engaged. The gun had not been fired. He also had a soft-sided holster in the front of Casey's pants. The holster does not have a strap to hold the gun in place. It's just, you put it there. There's nothing there to hold it in. So when I say holster, a lot of us think of how a police officer's holster is. Put a strap over it to hold the gun in the holster. This holster does not have that. Now, 2 years prior to his death, Casey had obtained a carry conceal permit. Casey had gone through the proper training, application process, and background check that allowed him to legally carry a gun in a car concealed. Casey would carry his gun, and he would carry his gun in that holster in the front of his pants. It was a handgun. Shortly after the shooting, the medics showed up, but it's futile, as Casey is pulseless, unresponsive, and when he was transported to Riverside Methodist Hospital, he was declared dead. Now, the defendant in this case has been charged with 2 counts of murder. And you're going to get the law from Judge Young. 2 counts of murder, 2 counts of reckless homicide. for the death of Casey Goodson Jr. And at the appropriate time, the judge is going to instruct you as to what all the elements are and the definitions that go with that, for you to make your determination as to whether we, as the state of Ohio, have proven both counts of murder or one count of murder and reckless homicide, all, one, or three of them. Doesn't have to be all of them. It can be one of the counts, two of the counts, or all three of the counts. I submit to you the evidence will show all three counts. So the evidence that the state will present will prove to you beyond a reasonable doubt that the defendant has committed beyond a reasonable doubt a violation of all three charges. So what's the evidence? So what's the evidence that we need to show? The evidence is, we're going to show it, the defendant did it. That the defendant acted intentionally. The defendant acted knowingly. That the defendant acted recklessly. You can have the same mental intent for all of them. Purposely is being the highest. Knowingly is in the middle. Recklessly is the lesser intent. It's heedless indifference. All three of these acts caused his death. Those are the elements. He did it. So what do we have? We have, after the shooting, the defendant's rifle was collected from him. His rifle was turned over to Sergeant Stanley with the crime scene search unit. The defendant agreed that six bullets had been fired from his gun. The 6 shell casings collected from the scene were recovered from the scene. And we have 6 shots in Casey's bag. The ballistics examination by the Columbus Police Department's examiner determined that the shell casings, the bullets recovered from Casey from the coroner's office, matches the defendant's weapon. Now, you also hear from Dr. Ann Shepler, who's a medical doctor with the Franklin County, she's the deputy Franklin County coroner at the time, who is board certified in forensic pathology. Dr. Shepler would testify, among other things, as to the location of Casey's wounds, entrance and exit wounds. You will learn that the bullets striking Casey struck him in vital areas, vital organs that are necessary to sustain life. You will learn that the six bullets were fired from his weapon, not one, but all 6 hit its target. From the evidence, we believe the evidence shows conclusively that the defendant acted purposely, intentionally, knowingly, and recklessly when aiming his weapon to shoot and kill Casey by pointing his weapon when he shot and killed Casey, and by pulling the trigger and shooting him 6 rounds from a highly powerful weapon, hitting him and striking him in the back. That's the mental elements. Now, Dr. Shepler will also testify to where these wounds were, and they were devastating, absolutely devastating. In her autopsy, the last element is cause of death. She concluded that the cause of death was due to gunshot wounds in the torso, and it's homicide. That's the manner and cause. Now, during her testimony, she will also testify to you, and you're going to see some photos. That's why we asked that in their questionnaire. Can you look at photos of something that might not be real pleasant? And we're going to present them to you because it's important for you to see, and you need to look at them, as unpleasant as they are. And that will be through Dr. Shepler. So, where did she find that the bullets went? Well, Vital organs were struck, causing these serious deadly injuries to Casey. One of the bullets went through the left ventricle of his heart. It was a heart shot. Went through the left ventricle of his heart. Multiple wounds to the upper lobes of his left lung. Wounds to his pancreas. Wounds to his liver, bowel, intestinal damage. Fractures of vertebrae causing hemorrhages of the spinal cord. Dr. Shepler also found that all 6 bullets traveled right to left in an upward elevation. Dr. Shepler found that Casey's back would have had to been turned towards the direction of the bullets when they were fired. You also hear from Amy Julia, and she spells her name a little different. I'm saying it Julia, so when you see her name, it's Qulia. It's pronounced Julia. She's a forensic scientist, forensic examiner for Firearms and Tool Mark Unit of the FBI Laboratory in Quantico, Virginia. Ms. Julia came to Columbus with her team and did an examination at the house. She determined that the bullets traveled through that metal mesh from outside to inside. She determined that the bullets traveled in an upward direction and right to left through that storm door that was to the backside of Casey. She also found that the storm door would be at least at a 45-degree angle when the bullets passed through the door. So Casey would have been standing, if the door's open here, he'd been standing like this, kind of twisted. To go into the house, unlocking the door, by the way, with subs in his hands. 2 items, 2 hands. Her findings, this places Casey between the storm door and the open door to the house. Now, Ms. Julia examined the door that opens into the home. There are no bullet strikes. She examined for bullet strikes on the porch, no bullet strikes. She didn't find anything that would strike the main door, which would indicate that the door was open and not closed, else it had gone through the storm door to hit that door. Ms. Julia's findings of the directionality of the bullets, they matched Dr. Shepler's findings as to the directionality in the bullets. And you're going to see from Dr. Shepler when she testifies as to the trajectory. She's going to tell you about the angles as to the bullets that passed through Casey's body. Ms. Julia is going to testify about the angles or the trajectory of the bullets going through the storm door. Now, ladies and gentlemen, so the state, I submit, will prove the charges. And if I think you remember in voir dire, there was all this talk about this justification. And we talked about, don't hold us to a burden that we don't have to prove. We're going to prove to you this is murder, 2 counts, and reckless. We don't have to prove justification, nor is it our obligation. That's them. They have to prove that that he was justified in his actions of taking Casey's life. I think somebody mentioned that whoever's got the burden, the other side just could sit there and play cards and not do anything. If they don't meet their burden, and if we've met ours and beyond a reasonable doubt of these charges, well, it's game over. But we're not going to do that. We get to challenge any evidence that they claim is justification. But you'll hear in our case evidence to show that Casey did not pose a reasonable threat to the defendant at the time he pulled the trigger. Casey did not pose a reasonable threat to the defendant or anyone else at the time he pulls his trigger. Because the evidence that in our case shows Casey wasn't even facing him. We know Casey was not a threat to the defendant by using the defendant's own words. He was caught on a body cam from another officer at the scene, Officer Penny, moments after the shooting, making a statement on the front porch. The defendant, you'll hear the body cam. You'll listen to it. We're going to introduce it. You'll see it. And you watch his demeanor in that body cam. Watch when he's talking to this other plainclothes officer. He unknowingly knows that Penny's standing there, who's a uniform officer, has his body cam activated playing. The other plainclothes officer doesn't have a body cam, and neither does the defendant. So what's he say? What's he say? Quote, when explaining what happened, quote, he came out the street, gun in his hand, going to the side door. He was going in with a gun in his hand. What he didn't say was, I was afraid. I was in fear for my life. I was in fear for someone else's life. Silence speaks louder than words, ladies and gentlemen. He's an officer, trained officer. He's not like us. This is not justification. But remember, they have to prove it. They have to prove it, that it was. Our evidence will show beyond a reasonable doubt that the defendant is guilty of the charges that we've charged him with. And the burden shifts to him, and that he's not going to meet his burden of proving to you by the preponderance of the evidence that he was justified. We're asking you to return a verdict on all the charges that the defendant fails to prove that he was justified in shooting Casey 6 times in the back. Thank you.
Any opening statements on behalf of the defense?
Thank you, Your Honor. May I proceed?
You may.
May it please the court? Mr. Collins, Mr. Nolder, Mr. Meade, Mr. Merkel, Mr. Schroyer, Mr. Shaw. Good morning, ladies and gentlemen.
Morning.
Mr. Schroyer just told you that Casey Goodson wasn't a threat on December 4th, 2020. Now, his own witnesses are going to tell you differently. So keep that in mind as you evaluate the evidence in this case, and keep that in mind as you evaluate the credibility of the state's case. On December 4th, 2020, a person was seen waving a firearm in a Nissan Versa. He pointed that same firearm at Jason Meade, an on-duty police officer, while Jason was in his unmarked vehicle. Jason has a duty to investigate this type of behavior, so he airs his intention to investigate to his team, to let his team know his location so that they are able to respond. At some point during the lawful pursuit of the gun-wielding driver, Jason turns his lights on to initiate a lawful investigatory stop. The gunman proceeds to get out of his car, looks at my client, takes off running, gun in tow, plastic bag in tow. The gunman is parked on the wrong side of the street. He sprints around a house, and Jason Meade pursues. As Jason chases after the gunman to try to investigate why he was waving a gun, why he pointed this gun at Jason while he was in a vehicle, why he is running away, and why he is trying to get into his house, into that house, he is screaming at the gunman, "Drop your weapon." He's announcing his police presence. U.S. Marshals, it's the police. Drop your weapon. All Jason knows at this time is that this gunman, this man, has a weapon. He ran away from him, and he's trying to get into a house. He's screaming, "Drop the weapon, drop the weapon." The gunman never drops the weapon. Instead, as that gunman is trying to get into this house, he turns and points a weapon at Jason, and in that split second, Jason believes he's going to be shot because he sees the gun point at him for a second time, and Jason shoots. You are going to see this firearm that the gunman pointed at Jason Meade, not once, ladies and gentlemen, but twice. That is what the evidence will show on December 4th, 2020. Now, opening statements. Just as you heard the judge tell you yesterday, they are an opportunity for each side to lead you down a path of what each side believes the evidence will show. Or, as is the case here, it's an opportunity for me to lead you down a path of what the evidence won't show. A roadmap or preview, if you will. For instance, Mr. Schroyer just told you that our client was reckless when he made the split-second decision to use deadly force. Ladies and gentlemen, the evidence will not show that Mr. Meade was reckless. Rather, the evidence will show that our client was trained to shoot until the threat that presented itself was over. The evidence will show that the threat in this case was the gun that was pointed at him. He shot to stop that threat of the attack before it shot him. Not acting with heedless indifference, but attacking the threat. The evidence will show that on December 4th, 2020, his weapon was on fully automatic. So when he pulled the trigger one time, it rapid fired 6 projectiles. The evidence will show, and you will hear, he never pulled that trigger again. The evidence will show, ladies and gentlemen, that this use of deadly force was not reckless, but rather it was due to Jason believing he was going to be shot on December 4th, 2020. Now, every time we as a defense prepare for a case, we like to look for what we call a theme. And what I mean by theme, ladies and gentlemen, is when you analyze a case, you've got witnesses, some professional, some not. You've got evidence, some physical, some circumstantial. But the theme of a case is what's left at the core fundamental concept of a case. The theme of this case, ladies and gentlemen, is one of justification. And that is because the evidence will show that on December 4th, 2020, Jason Meade was justified when he made the decision to use deadly force. And that's because of those 2 components that Mr. Collins talked to you about in voir dire. He's got to have a subjective belief. The evidence will show that Jason was in fear for his life, that he was about to be shot on December 4th, 2020. He had an imminent fear of great bodily harm or death. And that second prong, ladies and gentlemen, that belief was objectively reasonable based on the totality of the circumstances when viewed through the eyes of a reasonable police officer on the scene without the benefit of 20/20 hindsight. And we will prove that to you by a preponderance of the evidence. Now, with the benefit of hindsight, nobody here in this courtroom is disputing how tragic the events were on December 4th, 2020. And it is not lost on us that somebody lost a life, somebody lost a son, a brother, and a friend. However, as the judge told you yesterday, and he will tell you again, just like Mr. Collins told you in voir dire, you cannot consider sympathy or empathy while examining this case. And it's a tough task, ladies and gentlemen, because undoubtedly the state of Ohio is going to try to play on the fact that we are all humans here. They're going to show you a video. I'm sure you'll see the video time and time again. They're going to slow it down for you. They're going to show you those graphic photos that they asked you about in your questionnaire, and they are hard to see. And it's hard because we ask you to be almost clinical in your analysis. But that's what the law requires, that you leave sympathy and empathy out of your deliberations. And so every time the state goes to play that video, every time they put a tough picture up on that screen for you to see, Mr. Collins, Mr. Nolder, and myself would ask that you remind yourself of that instruction that the judge gave you. And I promise he's gonna give it again. That as you took that oath as a juror, you are not to consider sympathy or empathy when you analyze that case. And so every time they play it, remind yourself of what the law requires. Now, unlike the majority of cases here in our criminal justice system, we have a burden here. However, that does not alleviate the state of Ohio from meeting its burden. And its burden of proof, as you all are very well versed by this point, is higher than ours. Their burden is proof beyond a reasonable doubt. It is they that must prove each and every element of every crime they charged beyond a reasonable doubt. As the judge will tell you, beyond a reasonable doubt is proof of such nature you would rely upon it in your most important of your own affairs. Care for an elderly parent, surgery for a child. And if they fail to prove to you beyond a reasonable doubt each and every element of the crimes charged, judge will tell you your analysis stops there. You're going to hear, and in fact you just heard from Mr. Schroyer, about 3 competing theories that they're pursuing against my client. And they're competing, ladies and gentlemen, because of the different mental elements associated with those crimes charged. One is saying that he purposely killed, that it was Jason's specific intention to cause death. Ladies and gentlemen, the evidence will show that Jason's only specific intention on December 4th, 2020 was to stop the threat from him being attacked. The other is saying that he knowingly committed a felonious assault, which proximately resulted in the death. Again, ladies and gentlemen, the evidence will show he shot to stop the threat. And the third theory, ladies and gentlemen, that you've heard about is this theory of recklessness, that he acted with a heedless indifference. The evidence will show, testimony will show, that he shot to stop the threat. Now, they are not going to be able to meet their burden of proof, ladies and gentlemen. And that's because the evidence will show, through testimony and challenging the state's evidence, the evidence will show that the state started from a premise and worked backwards to make it fit. They're not going to be able to meet their burden of proof because the mental elements are going to conflict with one another. They're not going to be able to prove beyond a reasonable doubt each and every one of those mental elements. The evidence will show that the state's own witnesses are going to contradict one another. the state's own evidence will show, their theory will show, that their witness statements and their theory contradict with the physical evidence in the case. And the other reason, ladies and gentlemen, the state won't be able to meet its burden of proof is because of the expert witness that the state is going to call to the stand. He is a man by the name of Seth Stoughton. And Mr. Stoughton comes to...
Objection.
Overruled. This is the opening statement.
May we approach?
I have overruled it.
All right, thank you.
Thank you, Your Honor. This is because of a man by the name of Seth Stoughton. You're going to hear that Mr. Stoughton comes to two different conclusions. One conclusion relies on false premises and asks you to make inference upon inference upon inference, something that the court is going to instruct you that you're not allowed to do. Now, the second conclusion, a separate conclusion that Mr. Stoughton makes, you're going to hear him take the stand, and you're going to hear that second conclusion is the same exact conclusion that the defense experts come to. And that is, if Jason Meade believed, if he saw that gun come back at him, then the shooting is reasonable and justified. So that is why the state of Ohio will not be able to meet its burden of proof. And if that is the case, the judge will tell you your analysis stops there. But even if you find that the state does meet its burden of proof, in spite of all the issues that I just told you about, then and only then do you get to analyze the defense of justification. That is when our burden comes into play, ladies and gentlemen. And our burden, by law, is different than that of the states. And as the judge will tell you, our burden for justification is proof by a preponderance of the evidence. And what that means, ladies and gentlemen, is more likely than not. We have to prove that Jason, more likely than not, feared for his life when he had a gun pointed at him on December 4th, 2020. And we have to prove that it is more likely than not that his decision to use deadly force was reasonable, given the totality of the circumstances in the eyes of a reasonable police officer standing in Jason Meade's shoes as it occurred on December 4th, 2020. Again, we have to prove those two prongs, more likely than not. So I'm asking that you keep those two questions in the back of your mind as you listen to the testimony, as you listen to all of the evidence that is presented to you. Is it more likely than not that Jason was afraid he was going to be shot when a gun was pointed at him on December 4th, 2020, not once but twice? And is it more likely than not reasonable, given the totality of the circumstances, from the eyes of a reasonable police officer standing in Jason Meade's shoes on December 4th, 2020? Your task, ladies and gentlemen, and it's not an easy one, is that the judge is going to instruct you that you're not to analyze the defense of justification from your own life experiences, but rather from the eyes of a reasonable police officer on the scene. You have to look at the totality of the circumstances. The judge will tell you you're not to use hindsight in your analysis. You're not to look at avoidability, ladies and gentlemen, but rather you must look at what an officer could have believed about the situational need to use deadly force. Now, there's a reason, ladies and gentlemen, why the law of justification is written in this fashion. And that's because unlike judges, unlike juries, unlike me, unlike Mr. Schroyer, officers on the beat are not afforded the luxury of hindsight, of armchair reflection. Every single day, our men and our women on the police force put their uniforms on, not knowing if they'll return home to their families or their armchairs, not knowing whether or not they'll come home because of their job. Now, let me tell you a little bit about Jason Meade. He's a Marine, enlisted in the fateful year of 2001, right before September 11th, did 2 tours in Iraq, honorably served our country with the Lima Company, where he saw 11 major combat operations. He came back from Iraq and began his career as a law enforcement officer. He's got 2 children and a wife. And on December 4th, 2020, he faced every law enforcement officer's worst nightmare. You're going to hear that on December 4th, 2020, Jason Meade was on the SOFAST task force. It stands for the Southern Ohio Fugitive Apprehension Strike Team. It's a task force operated by the United States Marshals. It selected certain law officers from local law enforcement agencies to comprise this task force. You're going to hear that he and his coworkers started the day off like any other. Arrived to the task force around 6 a.m. for roll call at 6:30 a.m. They met at the SOFAST headquarters. The team lead, Dave Youngless, who you will hear from, explains to them the warrants they'll be working that day. You're going to hear that the team member assigned to that specific warrant provides the team intelligence so that the team knows what and who they're dealing with as they're executing the warrants. On that day, another detective agency called SIU, which stands for Special Investigations Unit, they're a branch of the Franklin County Sheriff's Office, they contact SOFAST and say, hey, will you execute this warrant for us? SIU was out conducting surveillance on near Estates Place on December 4th, 2020. So they contact SOFAST and say, hey, we want you to execute this warrant. We believe the fugitive may be in the home. So SOFAST responds, comprised of about 12 different team members, and they head out to assist SIU to execute the warrant on Estates Place, 4071 Estates. Our client, Ryan Rosser, Joseph Yorkowitz, Todd Barnhart, and team lead David Youngless, among others, go to the address to execute the warrant. The team arrives. The fugitive's mother, Ms. Barbour's mother, informs the team he's not present and gives the team permission to search the house. Jason and the team clear the house and did not find the fugitive they were looking for. The team goes to wrap up for the day. They are all getting ready to head back to headquarters to finish up some paperwork. Some of the team had trickled out, and our client was one of the later ones to leave. Outside of that residence on Estates Place, Jason has a conversation with Ryan Rosser and Joseph Yorkowitz as they're taking off their gear and placing it into their truck beds. Jason places his tactical vest, his pistol belt, and his handgun into the vault in the back of his truck. He places his rifle in the back seat. He drives from the residence, northbound on Estates Place. Ryan Rosser and Joseph Yorkowitz get into Ryan's vehicle and follow Jason. Our client turns left onto Ferris and stops at the red light at the intersection of Farrell and Carl Road. Jason is waiting to take a left onto Carl. Ryan Rosser and Joseph Yorkowitz are just a few car lengths back in the same lane. Jason, again, is at the front of the intersection. As Jason is waiting at the light, right outside of St. Matthias and DeSales High School, Jason sees a driver in a Nissan Versa approach the light at the intersection as the driver is waiting to turn left onto Ferris from Carl. Jason sees that the driver of this Nissan Versa has a gun with an extended magazine clip in his right hand. He is pumping the gun toward the windshield and pulling it back. He's animated when he's doing this. He's pointing it every which way. So Jason grabs his radio. He tells his team, hey guys, we have a guy waving a gun here at the intersection of Carl Road. He communicates with his team. Someone from his team asks for his location, and Jason responds with his location. Because as a sworn law enforcement officer, he's got a duty to investigate why this person is waving a gun in a vehicle, pointing it various different directions near a school zone. Right after Jason airs his location, the Nissan Versa makes that left-hand turn. And when that Nissan Versa makes the left-hand turn, he points the gun at our client in the vehicle. My client ducks down and reaches for his pistol. He forgets that he put his pistol in the vault in the back of his truck. He communicates with his team yet again what he is seeing as this is occurring. He's pointing a gun at everyone out here. He's coming past you right now, Ryan. Ryan's a few cars back. He is driving toward the target street. Someone asked, "Is this our guy?" Jason can see that it is not Mr. Barber and replies that this is unrelated. So let me take a break from September 4th, 2020. You are going to that intersection, ladies and gentlemen, of Carl and Ferris Road. A juror field trip, if you will. I want you to look and see how close you are to vehicles as they are driving around that intersection. Remember, Jason is in a large truck, so his view is elevated. So the evidence will show through testimony that he is absolutely able to see into the car as it is passing him. Now, on December 4th, 2020, as he warns his teammate, who is right behind him, that he's coming past you right now, Jason pulls into the intersection and makes a U-turn and starts to pursue that Nissan Versa with the gunman. Now, Jason's window, as he makes the U-turn, he turns and he's right next to Ryan Rosser's window. The windows are down, and so Jason communicates yet again with Ryan Rosser. That was the guy waving the gun. Now, unbeknownst to my client, Ryan Rosser and Joseph Yorkowitz did not have their radios on. However, other members of the SOFAS team did in fact have their radio on and did in fact hear our client communicate every step of the way. Unsure of exactly what was going on, but knowing that Jason had reported that there was a guy waving a gun and hearing the urgency in my client's voice, Ryan Rosser follows Jason. You're gonna see a video of these actions taken by Jason and Ryan. Thankfully, the security system at St. Matthias captured that very sequence of events. At some point during this pursuit, Jason Meade turns his lights on. Even though the vehicle is in fact unmarked, it is equipped with lights. He turns the lights on. Jason turns onto Estates Place and sees the suspect's vehicle parked on the wrong side of the road. Jason doesn't know it's customary for the family to park on the wrong side of the road. All Jason knows is that this person waving a gun parked on the wrong side of the road. My client realizes that he is not wearing his bulletproof vest. So he quickly gets out of his truck, hustles to get his gear on, vest and rifle. He airs that the suspect, yet again communicating with his team, that the suspect stopped past the target house. At the same time, officers Rosser and Yorkowitz pull up to where Jason is putting his gear on. Jason tells them in a bit of a panic, he's right at the end of the street, the guy waving the gun. The suspect gets out of the Nissan Versa, looks at Ryan and Jason. Jason is in his U.S. Marshal tactical vest. Jason can see the black gun in his right hand and yells, "That's him right there. He's still got the gun in his hand." Suspect looks at Jason in Ryan's direction and starts running. He's running toward 3996 Estates Place. He doesn't go to the front door, which again, my client didn't know it wasn't customary to run to the front door. All my client knows is that this suspect looked at him and took off running with a gun. At that point, Jason believes that he is deliberately evading him. Now let me back up, ladies and gentlemen. Jason can see that he's got a plastic bag in his left hand. But he can absolutely see, and testimony will show, that he saw that gun in his right hand. At this point, he believes the suspect is deliberately evading him. And that's the point, ladies and gentlemen. This is the point right here where everything changes. Again, ladies and gentlemen, on this jury view, you're going to see the proximity of the houses. They're all close together. The street's not wide. Look around. Take note of what you can see. Testimony will show what is going through my client's head at this point. This person is deliberately avoiding me. He has a gun. There's a school around the corner. There's a church around the corner. He pointed the gun at me. He was waving a gun at the car. And at this point, ladies and gentlemen, testimony will show that this becomes a potential active threat situation, as a gunman is now running loose through a neighborhood, and the police just lost sight of him. So my client hops in his truck and accelerates toward the end of the street. He sees the suspect pass the corner of the house. He was running toward a side door inside of a fence near the gate. He hits the brakes, jumps out of the truck, and sees the suspect trying to get into that home. My client yells, "U.S. Marshals, show me your hands. It's the police," multiple times. Jason is trying to close the distance on him to stop him from getting into that home. But he cannot see the suspect's hands. He continues to yell, "Show me your hands." Before the suspect makes entry into that home, the suspect's shoulders droop, and my client thought it was all over. Our client believed he was going to surrender. And in that moment, in that split second, ladies and gentlemen, the suspect turns toward the officer, looks in Jason's direction as he lifts his hand up, leveling the barrel of the gun toward my client. And in that split second, Jason steps to the left and fires, in accordance with his training, one shot until he sees the suspect fall. After that, ladies and gentlemen, he fires no more shots. Ryan Rosser is the first person through that door right behind our client. Todd Barnhart on the SOFAS team, who hears my client radio his every move, arrives a short time after. David Youngless, U.S. Marshal team lead, who hears my client air everything on the radio, also responds to the scene. You're not going to hear from these guys from the government. The government's not going to call them to the stand. But like I told you earlier, we welcome our burden of proof. We welcome the defense of justification, and so you will absolutely hear from Ryan Rosser, Todd Barnhart, and David Youngless in our case in chief. You are going to hear the corroboration of what Jason is going to tell you, and more important, ladies and gentlemen, what Jason told the detectives in a voluntary statement that he provided before the prosecution got any of their evidence.
Overruled. It's opening statement. Continue.
Thank you, Your Honor. This statement was given before Jason had an opportunity to see that video at Ferris and Carl. It was given before Jason had any type of review of any material. Listen for that corroboration, ladies and gentlemen. Listen as we call Ryan Rosser, Todd Barnhart, and Dave Youngless to the stand. Watch as they corroborate the chain of events that I just told you. If that's not enough, ladies and gentlemen, you are going to hear from an independent neighbor who, again, we as the defense will call to the stand, who hears our client give several commands to drop the weapon and identify himself as a United States Marshal. Now, outside of the witness corroboration that we will present to you, you are also going to hear that the physical evidence will corroborate the chain of events that I just told you. Listen to the physical evidence and the corroboration that it will provide. Video of Carl and Ferris that shows what I just told you. The fact that a gun was in fact found on the kitchen floor within an arm's reach of the suspect, not in a holster. A coroner who is going to tell you that the wounds are consistent with that version of events that I just gave you. They are consistent with somebody turning toward the suspect. You're going to hear. Now, Mr. Schroyer came up here and talked about this FBI agent, Quillia, who is going to tell you where Casey was in the door. No, she's not, ladies and gentlemen. She is not going to tell you the position of Casey Goodson and where he was in the door. The coroner and this FBI agent are both going to agree that nobody can tell you exactly where he was in that doorway. Nobody's going to be able to tell you the exact positioning of his body. Nobody is going to be able to tell you what happened to his body after that first bullet hit him. But what you will hear them say is that it's consistent with what Jason Meade has said. The evidence will show, ladies and gentlemen, that we will meet our burden of proof. And that is more likely than not that when Jason saw the barrel of the gun being leveled at his direction, he was afraid for his life. And that his decision was objectively reasonable when you look at the totality of circumstances in the eyes of a reasonable police officer. Now, I want to focus on that second prong for a minute. How are you going to judge what a reasonable police officer on the scene would do? You're going to hear from two defense experts, decorated law enforcement officers with decades of experience. Between the two of them, they have trained thousands of law enforcement officers all over the world on deadly force. Their names are Kevin Davis and Jim Scanlon, both trained police officers in the state of Ohio. Kevin Davis has been in law enforcement for almost 40 years. He's a certified force analyst. He's an instructor with the Department of Homeland Security with impeccable credentials. Jim Scanlon was a law enforcement officer for 33 years, 19 of which he served on SWAT. He started his own company in 1999 called the North American SWAT Training Association, or NASTA for short, where he consults and trains in officer-involved shootings, firearms, hostage and barricade situations, and critical incident training. Listen and compare them to the state's expert, who was maybe a police officer for 6 years, and certainly not here in the state of Ohio. Jim Scanlon and Kevin Davis are going to walk you through why Jason Meade was reasonable on December 4th, 2020. With over 70 years of experience between the two of them, listen to each as they explain how Goodson's actions here dictated what Jason Meade did next. Listen as they both will tell you an action is always faster than a reaction. And that's according to training. That after standing in Jason Meade's shoes, experiencing what he experienced, seeing what the person with the gun did, it required immediate action on behalf of Jason. They're going to walk you through some factors that the court is going to tell you you are allowed to analyze when determining whether or not this was objectively reasonable. Keep those factors, ladies and gentlemen, in the back of your mind. The first factor that you're able to look at when determining the reasonableness of whether or not this shoot was justified is the severity of the crime at issue. Listen as these two tell you why Jason Meade had a lawful objective for taking action, and that the severity of the crime that he was investigating was someone waving a gun in a vehicle, pointing that gun in a vehicle, that car being around a school, and the person taking off with the gun. At that point, ladies and gentlemen, you will hear that the severity of the crime is such that these experts will tell you that you have a potential for an active shooter situation. Evidence will show that after analyzing this factor, that the decision to use deadly force is more likely than not reasonable. The second factor you're able to consider is whether the gunman, whether Mr. Goodson, posed an immediate threat of physical harm or death to our client. Listen as both of these experts take the stand and tell you that when a gun is pointed at a police officer, there is no higher threat to the officer. It is every officer's worst nightmare to stare down the barrel of a gun. Both of them will tell you that leveling the gun in the direction of an officer is absolutely an immediate threat. Evidence will show that the decision to use deadly force when you analyze this factor is more likely than not reasonable. The third factor you're able to look at when determining whether or not the use of deadly force was reasonable is whether the suspect was actively resisting or attempting to evade arrest. You're going to hear to drop the gun. You're going to hear that Casey Goodson looked in the direction of Jason Meade and took off running. You're going to hear that Jason Meade had to run after him. You're going to hear that when someone looks at the police and they run, they are actively trying to evade arrest. Evidence will show that when you analyze this factor, that the decision to use deadly force is more likely than not reasonable. The next factor you're able to consider is the suspect demeanor, whether Mr. Goodson was non-compliant. You've already heard of that, ladies and gentlemen. So the evidence will show that when you analyze this factor, when you're to consider the reasonableness of whether or not the decision to use deadly force was justified, that was more likely than not reasonable. The next factor you're able to consider is the duration of the confrontation. You'll hear testimony, ladies and gentlemen, that it took Casey Goodson 4 seconds to get from one end of the street down to the other end of the street. You're going to hear testimony of how quickly this transpired. Again, the government is going to try to slow it down for you. But you're to take it in the eyes of a reasonable police officer as Jason experienced it on that day. It's going to testimony will show that this event transpired quickly. So when you analyze that factor, the evidence will show that the decision to use deadly force is more likely than not reasonable. Another factor that you're able to consider is the possibility of that suspect being armed. Again, ladies and gentlemen, evidence will show that this was no possibility. This was an actual threat. This fact is uncontroverted. The fact that Casey Goodson was armed on December 4th, 2020. So the evidence will show that this decision to use deadly force when you analyze this factor is more likely than not reasonable. Now, the judge is going to tell you that you are to examine this case in your deliberations from the eyes of a reasonable police officer perspective, standing in Jason's shoes at the time, experiencing what he experienced, seeing what he saw, hearing what he heard at the time that deadly force was employed, not what Casey Goodson did or did not hear. The law tells us, and the judge will tell you, that you have to look at it from this perspective. The law does not say you must put yourself in the shoes of Mr. Goodson on that day, experiencing what he experienced, hearing what he heard. It says from the perspective of the eyes of a reasonable police officer, going through everything that Jason Meade did on that day, not Casey Goodson. Now again, you're gonna hear from the state's expert. This state's expert, granted, has less experience as a law enforcement officer than Kevin Davis and Jim Scanlon. But remember, ladies and gentlemen, he's going to tell you the same exact thing that Jim Scanlon and Kevin Davis tells you. And that is, if Jason Meade believed the gun was pointed at him, if that gun was pointed at him, if he saw that gun being pointed at him, then this decision to use deadly force was reasonable and justified. So, ladies and gentlemen, in recap, we believe the evidence will show that the state of Ohio will not be able to meet its burden of proof. And that's because testimony will show that the state started with a premise and worked backwards. They're not going to be able to meet their burden with respect to the mental elements. Their own witnesses are going to contradict one another. Their theory is going to contradict the physical evidence. But even if you do somehow find that they have in fact met our burden, the evidence will show that at the end of our case, we will have met our burden of proof by a preponderance of the evidence, or more likely than not. And that is because that the evidence will show that on December 4th, 2020, when that gun was pointed at Jason Meade, he was more likely than not in fear for his life. And that is because the evidence will show that his decision to use deadly force was more likely than not reasonable. At the end of this case, my partner, Mr. will come before you and ask that you find Jason Meade not guilty of all of the charges, because we have met our burden of proof that he was in fact justified by a preponderance of the evidence. And this justification defense acts as a complete defense to all charges. I thank you for your time, ladies and gentlemen.
Ladies and gentlemen, is that me or?
Stepping.
Oh, okay. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. Ms. Wright's gonna scream at me every time if we take a break, I don't read that to you. Do we want them, the bus is at 2, do we want them back here?
Commission at 1:30.
In the jury commissioner at 1:30? All right, so be in the jury commissioner at 1:30. Sure. Have a seat. The jury commissioner are at 1 o'clock. All right, go with lunch.
All rise. So,
What happened? I have to keep moving my mouse or else my computer goes down. We're in the middle of that and I'm having to log on if I don't do that.
I'll see if Matt can fix it.
Not typically gonna have
Yeah.
an hour and a half straight. Whatever time you guys wanna be back, the bus is.
Oh, okay, so we don't have to come back in the court of law.
You can give him a charge on jury. He doesn't give a charge.
Yeah, I do, there's a two
You
sentence,
don't have to be here for that. Do you want us here or?
be here by 1:30.
Your Honor, I want to talk about where we dropping them off.
But we can do that in back.
So they should all come back tomorrow at 9. Tomorrow at 9 for them.
Yeah.
Yes. All right. Okay, tell them, the two guys in the suit.
Yeah, I got it.